Afternoon, all. Welcome to this, what would you call it? Pleasant Friday, I suppose. My name is Chris Irons. I am a Strata advisor with Hines Legal, former Commissioner for Body Corporate and Community Management. And with me today, as always, Frank Higginson, partner at Hines Legal.
Your trusty sidekick, mate.
Well, and vice versa, Frank. Welcome, everyone. And as always, thank you very much for tuning in today. There are many other things that you could be doing on a Friday afternoon. So the fact that you have decided to come and listen to us talk, we really appreciate it. Thank you. Don't forget to please like and share the Hines Legal Facebook page, in particular this broadcast today. Now today, Frank, bit of a touchy one. We called this nuisance owners, and I think almost within a nanosecond of me having posted that topic, or us having posted that topic on Facebook, we got some reactions, didn't we?
We did. And I think, ladies and gentlemen, what I would say, this is one of the reasons Chris has joined us as a law firm in the context of before his arrival, and you'll talk about this in a minute. Nuisance, I suppose, is the word that's used in the legislation. So in terms of section 167, we'll cover that off in a little bit. Nuisance is the word that's used. So that is then the word that, from our perspective as lawyers, has been consistently applied to the people that we are consulted with respect to, I suppose, taking some form of action or proceeding against. So that's the legal blinkers that up until Chris's arrival with us 3.5 months ago, the way we looked at it. So today's session is going to, I think, be a little bit wider than that, isn't it, Chris?
I think so, Frank. Yeah, and look, let's address the elephant in the room first of all, the title nuisance owner. So I think we put it that way from a practical perspective purely because it's just 2 words, so that's as few words as possible. That's the terminology that people tend to use a lot, nuisance owner. But yes, let's just clarify, nuisance is not only about an owner. Nuisance is about a nuisance committee member. Nuisance is potentially about a nuisance caretaker. Nuisance is also, Frank, isn't it, about a nuisance tenant for that matter as well.
Or an occupier in the legal word. Yep.
But there was method to our madness in starting it off that way, because what it demonstrates really clearly is the danger in labelling. Labelling is useful in a lot of respects, and labelling is good in helping to provide some definition. Labelling is less helpful when it comes to people, though. The instant that you call somebody nuisance, or whatever the term you might want to use, you've immediately labelled them. And things, generally speaking, tend to go and keep going downhill after that. So I think, Frank, you and I are agreed it is far preferable to talk not about people, but about situations as being challenging, isn't it?
Agree. And that's really what they are. And I think the more that we deal with strata disputes, and certainly the season for them at the moment across a range of fronts, but maybe that's your arrival, mate, that brought them with you. It's not usually everyone about everything. It's about a specific set of circumstances where people get entrenched, and that's where the fight starts.
Absolutely. Just a reminder all, you can ask us questions live today. We'll try and get through as many of those as we possibly can. With all that in mind, as you know, Frank, I'm a big believer in why. So if something is going wrong in a body corporate context, I think it always begins with asking why. Where is that coming from? When we talk about challenging situations, there is often, or if not always, I think, a reason. What is lurking behind? So let's just say, for example, you've got behaviour from a person, owner, occupier, committee member, caretaker. Where is that behaviour coming from? What's driving it? There are actually a number of reasons why people behave the way they do, and particularly if behaving a way that, let's call it inappropriate, for want of a better expression. It could be there's a medical condition at play. We'll actually talk about an adjudicator's order in this session that touches upon that issue. A really good one at the moment, Frank, isn't it, is just people are under stress, aren't they?
Yep, mate. This still has a lot of the hallmarks of the GFC for me. Up until the GFC arrived in 2008, life was bitchy keen. No one cared about money, bills got paid, everyone was happy, no one was under pressure. And the moment the GFC arrived, that tension just created a whole lot of explosions that I can just, it's got that same vibe for me at the moment, where almost no matter what you do, short of being, I suppose, a Woolies or Coles shareholder, you are going to be impacted in some way by what's going on with COVID.
That's right. And then there are a couple of other reasons. There might be a language barrier. There might be some cultural issues at play. There might be a disability that is preventing really good comprehension. A general lack of understanding. I mean, let's be clear. Body corporate legislation is complex stuff. Anybody who's ever read it, I'm sure everyone reads it day in, day out, reads it at night. You know, parties with it on a regular basis. It is thick. It is voluminous. It is wordy. One of our clients, Frank, said that they counted 180,000 words.
Yep. And there's little nuances in the modules that change. So yes,
it's extraordinary. When somebody is presented with concepts and words and terms that are difficult and technical, they can actually materialize themselves as challenging behavior. And sometimes those behaviours come about because of an issue that happened in the past that is completely unrelated to what's going on right now. So, for example, there might be a fight about car parking, for argument's sake, but in actual fact, the tensions that are arising out of that might stem from years earlier, where a relatively simple improvement request was denied or drawn out or protracted. I tend to call that poisoning the well. That something happened way back in the sands of time, somebody has carried that negativity through to the current case. And finally, and let's just be really frank, no pun intended, about this, some people are just awful, aren't they?
They are. They are. And I suppose that's where we get to from a legislative perspective and from, I suppose, a human perspective. And before Chris joined us, we had done, I suppose, seminars for 5 years together. Of course, he did them with other lawyers as well. He had to do that in his former role. One of the things, Chris, I remember at one of the early seminars, said you're never, ever going to be able to legislate human behaviour. And that's it. Some people are going to be rude. Some people are going to be childish, are going to be immature, are not going to explain themselves. And there is nothing, in a sense, anyone can do to, well, with respect to that. If people are going to be rude, they're going to be rude.
That's right. I mean, there is no law against immaturity, for example. Neither can you regulate how people talk to you, and you can't make people be nice. Those are realities. And I'm sorry if they're confronting realities for people watching this, but that's just how it is. You are remember, the name of the legislation is Body Corporate and Community Management. Think about that word, community. You are part of a scenario in which you have to share space and decision making with a whole lot of other people that you've not met before in your life. It's almost, you can't guarantee that you will get along with everybody in that situation. That doesn't mean that it should always be negative, far from it, but things can go wrong because people are people. Let's just sort of address that right at the outset. So, what happens in the body corporate context, Frank, isn't it, that people tend to use a lot of words interchangeably when they're talking about these kinds of situations. And the words that we typically hear, I used to hear all the time as commissioner, words like abuse, harassment, bullying, and nuisance. All of those are valid, and obviously if people are feeling those things, that's tough. But in the body corporate context, very few of those terms have much meaning, do they?
Correct. And that's really, I suppose, ladies and gentlemen, what we're talking about today is obviously we could be here, I suppose, for the next 24 hours talking about all of the examples that have, well, I could do that across my desk, let alone what Chris would have seen in 5.5 years as commissioner in terms of material. But what we are really dealing with is what the rights of people in bodies corporate have effectively with respect to poor behaviour. And so when you look at bullying, which gets thrown around a lot, there's absolutely, from a fair work perspective, from an employment perspective, if bullying in a legal vacuum in relation to fair work is where people or a person acts unreasonably towards someone else, and that behaviour creates a risk to health and safety. So if I get off this webinar and I abuse the daylights out of Chris for not introducing me as the most eminent legal professional in the Strata world, that is me bullying him. But that doesn't actually apply to anything that happens in Bodies Corporate. Other than in the slight context, which we're not talking about today, is people who are workers, which can include caretakers who are companies and body corporate managers. They may have rights with respect to bullying, but even then, and this is one of the issues that comes up, is when you go to the Fair Work Commission, bullying isn't a costs or rewards jurisdiction. It's a jurisdiction that is designed to stop the bullying happening, and that's it.
Yeah, that's right.
So, yeah.
A lot of the time people will use those terms interchangeably. As I said, there are other organisations that deal with those concerns. For example, not always well known, but there is a federal e-safety commissioner, and you can report online abuse through that agency. So that remains an option. There are also not-for-profit organisations who are in the business of trying to eradicate bullying, or at least address the behaviour that leads to it. When we talk about a body corporate context, though, there is such a thing as nuisance. So for those of you who are unfamiliar with it, Section 167 of the Body Corporate and Community Management Act talks about nuisance. But Frank, it's not nuisance as perhaps most people would understand it, is it?
No. So the legislation is very, there's probably a two-pronged approach. And I suppose for those of you out there that have got your bylaws handy, it's a much better approach to have a bylaw that deals with nuisance more broadly than what the legislation actually does, because the legislation relates to nuisance that is conducted from a lot or the common property in a way that interferes unreasonably with someone else's use and enjoyment. So the biggest decision, and we've got a couple of them we'll talk about, but there's one called Tank Tower. So what we might do after this, Chris, is sort of put out on our social channels a link to the newsletter we wrote on that at the time. That was one where an adjudicator compared 167 with the nuisance rights versus what a bylaw actually created, and decided a bylaw was a much better way to go in effect because it's more broad. But when it comes to the legislative interpretation of nuisance, first thing is it's an objective test. So it's what a reasonable person would view. So it's not a subjective test in terms of, Chris, you're really annoying me. It's what a objective person would look at and say, well, Frank, you shouldn't be annoyed by what Chris is doing, because the reasonable person wouldn't do that. And then inside that, it then comes back to what the individual circumstances actually are. So in Tank Tower, for example, that related to voluminous, incessant, repetitive correspondence to a committee. And the adjudicator has acknowledged committees are volunteers, they shouldn't have to put up with this, and particularly they don't have to put up with the rudeness and the tone that came out in that correspondence. So while there is a statutory right there, it's not quite as broad as what it should be when you get to if your bylaws are done properly. And most bylaws aren't drafted to have a nuisance bylaw in it.
Probably should add also, Frank, something which is often overlooked and very closely related to nuisance is something called interference. So it's the section immediately before nuisance in the legislation. And this talks about interference with easements, support or shelter, or interference with utility services. And these are prohibitive provisions. And I'm paraphrasing here, but it basically says an occupier of a lot must not interfere or permit interference with utility infrastructure. And there is actually a 100 penalty unit penalty. It's not very often that there are penalties under the body corporate legislation, but that is one instance where there is, and that can be enforced through the magistrates court. Back to nuisance and bylaws. Nuisance proceedings, bylaws proceedings can be enforced through the Commissioner's office. As Frank said, there is a test that applies. You cannot just rock on up to the Commissioner's office and say, I'm experiencing nuisance, therefore I want an order against this person. There is a considerable body of work that goes with that. We identified a couple of cases that we wouldn't mind just briefly touching upon today, and I mean pretty briefly. So Frank's already talked about Tank Tower. It's the case that's often referred to when we talk about a challenging individual. In this case, it happened to be a challenging owner. Another one that I want to quickly draw your attention to, so just to clarify, all adjudicators' orders are available on the AustLII website, www.austrlii.edu.au, and there's a search function there for adjudicators orders. One order I wouldn't mind drawing your attention to is for a scheme called River City Apartments, where the body corporate brought a proceeding against an owner for nuisance. I think this one's interesting, frankly. We were talking about it before, because the adjudicator found that nuisance had been made out, but there were some very particular circumstances here, weren't there?
Yeah, noise and shouting. So there's probably been a few of these, and we do get, you know, the party complaints. And I suppose the starting point for all of these things in relation to any application that you would be making in relation to nuisance has to be evidence. Has to be detailed evidence about what has taken place, when it has taken place. And it's not so much then how it might have affected you, but it's what that really is then open to the adjudicator to make a decision from their end in terms of whether objectively that particular set of conduct does cause a nuisance. And I think probably the example I use, or the line I use a lot, and section 167 is the same, is that what people are protected from is effectively people using the lot or common property in a way that interferes unreasonably with the use and enjoyment of yours. So what that says to me is that reasonable interference is allowable. So it's not any interference. So, and we quite often have the example come in where kids might be out playing on driveways on skateboards or bikes or whatever it might be, and the bylaw says kids shouldn't be allowed to do that. So leaving aside whether that bylaw is oppressive or unreasonable, and this is one of the things, we are, as Chris said, bound by the Body Corporate and Community Management Act. So everyone in a body corporate is tied together legally by virtue of that legislation, but there's some rights that don't necessarily accrue. So the example with the kids on skateboards, I'll say to clients, is, well, imagine if you're in a normal suburban 405 square metre block and there were kids on the front, on the driveway or out on the road playing, what could you do about it? And the answer is nothing. And in that sense, it's not dissimilar from a BCCM Act perspective. Although you can, and this is where I suppose we got here, Chris, with River City, is I think there was mental health issues, and the person was sitting on their balcony yelling abuse at other owners and occupiers.
But I think that really highlights a point. So the adjudicator is quite clear in their order that the nuisance was made out, but the adjudicator went into a little bit of detail about that individual and their mental health issues. It raises the point, doesn't it? It goes right back to my point at the beginning. Where is this behaviour coming from? In this case, it's coming from a particular place, and to the extent that that owner probably is incapable of controlling their actions in that particular circumstance. You then have to ask yourself, is that the most effective method of dealing with that problem? And look, let's be clear, nobody is saying that it isn't a problem. Of course it is, and that would be incredibly distressing for anybody to deal with. But is that the right way to deal with the problem? I might just flick over to a couple of questions before I forget. Someone has asked about an owner who vandalised their own property and then refers to it as common property. So I'm not sure which it is, because the two are quite different. If someone's vandalised their own property, someone's vandalised their own property. If someone has vandalised common property, very different story. That's a police issue, frankly. Frank?
It's a criminal event, absolutely. Yep. So, and I suppose one of the other things with bylaws, you might see them saying that bylaws, you know, if someone vandalises common property or disturbs it in a way that costs the body corporate money, then the body corporate can recover it under the bylaws. No, they can't. So it's a civil claim. The same as if you came to my house and damaged my front wall, my option would be to sue you for the compensation to put that back right.
Yep.
And I suppose, Chris, that is really consistent with the question below that one on the feed in terms of interpretation. One of the difficulties with any piece of legislation is interpretation, and even Chris, in one of his former lives, actually drafted legislation. So worked in the Office of Parliamentary Counsel and late at night producing urgent bills. So I've got a lot more insight into what goes into drafting than I previously have had after working with Chris. And one of the difficulties is that they can't legislate everything. And that's why we get to QCAT, courts, Commissioner's Office and those sort of things. And the Commissioner's Office has or the adjudicators in the Commissioner's Office have a very wide discretion to make orders that are just and equitable in the circumstances. And quite often then that comes back to, and we talk about it a lot, is bodies corporate acting reasonably. So what acting reasonably is in any particular circumstance going to be dependent on what has gone on.
Yep.
There's no hard and fast rules you can apply to that ever. And to be honest, that's probably a reason that we as lawyers are always going to have jobs, because it's trying to take previous decisions and apply those decisions to the individual facts before us to form a view about whether someone has acted reasonably or otherwise.
Just another question about penalty units. Thank you. I should have clarified that. Yes, it is a dollar value. So at the moment, I think it's about
$133.45, and normally it's indexed to CPI. So that way they don't need
penalty unit.
It is. 100 units is
13, almost 13,500. Yeah.
My daughter's in grade 6. She probably would have done that quicker than I could.
Yeah. So look, that's that. Look, with sort of taking a look at the time, I think we were very keen, Frank, to present solutions. So
it's all well and legals, absolutely.
Yeah. So it's all well and good to talk about the problems. Let's talk about a few solutions now. So for me, you go back to the start. You try and have an appreciation for where the behaviour is coming from. I think by doing that, you might actually get to a point where you can better manage it and better understand it, and that makes life a little easier for everyone. You should also have a think about whether or not you address the behaviour with the individual. My big qualifier there is you don't do that if it's unsafe or you think it's going to be unsafe. But you'd be surprised the number of times that somebody is presented with a situation and then they weren't aware it was actually a problem. So that, and more to the point, if you do pursue these matters through the Commissioner's Office, you need to have some evidence of having tried to solve it yourself. Anyway, there are a lot of agencies that you can do referrals to. For example, if the behaviour you think might be coming from a person's lack of capacity, so decision-making capacity, I mean there, the Office of the Public Guardian, which is a Queensland government agency, might be able to assist in determining if there is actually somebody there who has an order over them. And it might therefore be easier to talk to that person. And that applies a bit more generally. If somebody is a bit problematic, maybe there's a family member who could be called upon to assist. That can actually get a bit of cut through in some cases. And then, as Frank and I were talking about, there are the legal options. A nuisance application, bylaw proceeding. Before that, of course, Frank, you need to amend your bylaws to have the right bylaw in place, don't you?
Absolutely. And I think probably one of the other things is just practically what happens and what we find in Strata is that most of the disputes and most of the issues are more emotional ones than financial ones. You know, in financial disputes, people settle, they're not living with the person that's causing the grief, they're not getting circulars from the committee about whatever it might be. So everyone can become really entrenched really quickly, and I understand how that happens. And so probably one of the things that I say to all of the junior lawyers that start with us is you need to have the 24-hour rule. So this, and I think if everyone applied this across the board in Strata, we would have a lot less fights. And by that, I mean, when you get that email or that snarky correspondence or whatever it is that really makes your gut clench, winds you up, by all means, draft a response right there and then, but do not send it for a day. If you sit on it for 24 hours, firstly, the heat comes out of those immediate diatribes. And I can tell you now, and Chris will have seen it as well, some of the evidence that we put into proceedings or some of the material we're advising on is email chains that go for 15 or 20 emails that all happened in the space of 2 hours on a Thursday night. So imagine for a second if when that landed, you didn't respond. And sometimes that means you might need to be the bigger person. As annoying as that might be, it will give you more sanity in the long run, sitting on that correspondence and not sending it. I know that's how I operate because lawyers are good at needling other lawyers. So as much as I'm more of a lover than a fighter, but I can be a little bit punchy if I need to be. I suppose that's the chameleon that lawyers have to be. But when I get one of those pieces of correspondence that really does rile me up, I park it. I give myself a task to look at it. Might even be next week.
Yep.
It's certainly not going to be today, because I don't need to deal with that today.
Let's talk about let's talk about emails very quickly, because I think that's a really good point, Frank. So that draft stuff is really important. Don't hit reply all would be another tip that I would give. Just because everybody else is CC'd into the email doesn't mean that you have to reply to everybody else. The more people that you involve, the more chances it goes wrong.
And
very quick note
of defamation.
That's right. Very quick note on the email addresses. Here's a fun fact. It is not an obligation that you provide your email address for body corporate law. So you are not obliged to provide your email address for the body corporate role. Of course, it is extraordinarily convenient if you're able to do so, because then you won't have to get everything in paper, but you don't have to do it. However, this then brings up my next point, which is that consider creating separate email addresses. Don't use your personal email address. Set up a wholly distinctive email address for body corporate business. So if you're on the committee, for example, johnsmithcommittee@gmail.com. That's the address that you use for body corporate business. It creates distance and space. So you have life and you have body corporate. The two should not meet. I think that actually is a really practical way of lessening a bit of stress. And then finally, you do all of those practical things. There's such a thing as alternative dispute resolution, which is actually one of the reasons that I'm working with Irons and no longer commissioner. So one of the things that I do is mediation for body corporate disputes, and I've got a fairly wide brief to do that. But Frank, we're working with a couple of committees here in Brisbane at the moment, aren't we, in relation to challenging individuals?
Yep.
So we've got one scheme at the moment that we've done a workshop with, talking strategy and tactics moving forward, and we're coming up with some, what I think are some pretty novel approaches to dealing with that particular situation. It's a work in progress.
Absolutely.
We've got a second building we're dealing with at the moment where we're doing something similar. The circumstances are very, very different. And this goes to a question that's been asked here about what is considered reasonableness. Yes, there is an objective test for reasonableness, but what is reasonable is different in every situation. Why? Because every building is different and every person that lives and works in that building is different. Therefore, everything that is reasonable is dependent upon the circumstances. So hopefully that's answered that question. But getting back to my point, there are ways to resolve it. I'm offering those services. We're trying to look at non-legal solutions. Another question's been asked here, why is there no avenue to resolve differences at a local level and not go directly to adjudication? There are avenues to resolve differences. A lot of what we've been saying today is about resolving differences and not going to adjudication. There are plenty of options to do that. Frank, what have we missed?
Probably the one we get a fair bit of too is really it's managing expectations. So where I'd get to is no one needs qualifications to get on a body corporate committee, and that will never be the case. No one needs qualifications to buy into a body corporate. And this is the 188,000 words that's in the legislation in terms of what people should be doing and how they should interact and what should be going on. We're subject to all the personalities involved. But where I think a lot of people go wrong, and I suppose this starts at a committee level, and this is something that we are working on in terms of education, is a protocol for dealing with communications in the building. I mean, the amount of times that we've had, and you see it, someone, an aggrieved lot owner, occupier, whatever it might be, will fire an email to all 7 committee members, and then we have an email exchange between everyone, when I think in a vacuum, and this is, again, I suppose, Chris, this is where the legal advice comes in, is the vacuum is what should happen is a individual person, a member of the committee, can't make a decision. Only the committee can make committee decisions. And the reality is that a lot of those decisions should be made at committee meetings. So in that sense, it should almost be, thanks very much for your feedback. We'll table at the next committee meeting and we'll come back to you, in the absence of there being some extreme urgency to that particular request. So it's those sort of, that expectation management from owners where committees are volunteers. They're not there at the beck and call of everyone. And yes, people might be aggrieved in relation to certain issues, but that doesn't make it necessarily urgent. You know what I mean? You might want it resolved. And that's certainly what came up in Tank Tower was the committee are a bunch of volunteers and they shouldn't be subject to this.
Absolutely. Couple of questions very quickly because we are running out of time. In relation to bylaws, do all the owners need to vote on them, or can the committee authorise it? Absolutely, the owners need to vote on it. So bylaws need to be passed to the general meeting, not by
by special resolution. So effectively 2/3 of those who vote, voting in favour.
So if your committee is saying to you that they have authorised and passed a new set of bylaws, no, that's not correct. Another question, a bit of a random one, but sorry, I can't speak, but a relevant one. Do you think there needs to be more regulation in terms of who can be a body corporate manager? It seems they can suddenly decide to be a body corporate manager and make people's lives hell. Yes, that's right. Anybody can be a body corporate manager. There's no licensing or regulation. I'm going to be a bit in Queensland. I'm going to be provocative though and say that's not the issue. And it's not the body corporate manager that's the issue in most cases, not all, but most. A body corporate manager acts on instruction. They are not a decision maker. A body corporate manager acts on instruction from its committee. They have a contract between themselves and the body corporate. Body corporate manager is not answerable to an individual owner. A body corporate manager is answerable to the body corporate as a whole. So if you're saying to me, a body corporate manager is making my life hell, I would say to you, you probably need to be reframing the kinds of inquiries that you're directing to your body corporate manager, and you need to be changing your expectations of how that works. Frank?
No, I completely agree. You know, and we have, I suppose you'd have people that would probably accuse us of being really difficult with respect to their individual interests, but yet again, we're acting on the instructions of the committee. So, and there is a lot of confusion out there from time to time about who does the individual roles in Strata, from resident manager to body corporate manager to committee to lot owners and so on. And it's usually the body corporate managers might be firing the bullets, but they're not loading them.
That's right.
It's my experience, it's very rare to have a body corporate manager, particularly a professional one, go off half-cocked in terms of taking on an individual owner on an issue without instructions from the committee.
Yep, absolutely. Very, very quickly, what about where there is an out-of-control committee and owners trying to straighten things out? Well, you can get rid of a committee. You can resolve to have a committee voted out. Be careful what you wish for, is my comment on that one. It's all well and good to say the committee is useless, get rid of them. You've got to have somebody to replace them. You've got to have somebody to step in, and who's to say that they would not be as bad, if not worse, Frank?
Agree. And the other thing is, I suppose they're there, you know, and this is the body corporate democracy that we live in. A committee doesn't have a fixed term. They're certainly removed at every AGM and then voted back in, but can be removed by ordinary resolution on the way through. So if you have the numbers to get rid of them, then you're absolutely entitled to do that. But if you don't have the numbers, then, and this is part of the brutal reality of Strata democracy, is if that's the will of the people to have those people there representing their collective interests, and those people are not the people you want, to me, that's probably no different to if you're living in any country in the world at this point in time, be that Donald Trump, you're Republican or you're Democrat, or Scott Morrison, you're Liberal or you're Labor, that's who you've got.
But what you can do is you can challenge and focus on individual issues. So if the committee has made a decision that you consider to be not correct, or you know to be not correct, you can do something about it. So you just need to be clear. Is your issue the committee, or is your issue a decision that they have taken? Very, very quickly, run alternatives to dispute resolution. We've outlined a few of them here. It might be a good idea if you wouldn't mind touching base with us afterwards, and we can delve into that in a bit more detail than we can in this kind of forum.
And that is the mediation bit with you,
absolutely.
Chris, more than anything else. It's sort of, you can take your 6 to 8 months in the Commissioner's office. Yeah, absolutely.
It's not just that, it's other stuff too. We will need to wrap it up there. Don't forget, we're back next Friday at 2, and we'll be announcing our next exciting topic during next week. There's a lot of talk floating around about legislative changes at the moment. We'll always prioritise that discussion if it comes up, but stay tuned and we'll see how we go. Otherwise, thank you everybody for tuning in today. If you do have follow-up questions, by all means put them on Facebook. We can't necessarily give you an involved legal advice to one of those, but we can start to point you in the right direction at the very least. Frank, thank you. As always, it's been a pleasure.
Have a good weekend, everyone.
Everybody have a great weekend. We'll see you next week.